Mr. Lieu.
Thank you, Chairman Nadler. I first swore an oath to the Constitution when I was commissioned as an officer in the United States Air Force. And the oath I took was not to a political party or to a president or to a king. It was an oath to a document that has made America the greatest nation on earth. I never imagined we'd now be in a situation where the president or commander-in-chief is accused of using his office for personal political gain that betrayed U.S. national security, hurt our ally Ukraine, and helped our adversary Russia. Now, the Constitution provides a safeguard for when the president's abuse of power and betrayal of national interests are so extreme that it warrants impeachment and removal. It seems notable that of all the offenses they could have included and enumerated in the Constitution, bribery is one of only two that are listed. So, Professor Feldman, why would the framers choose bribery of all the possible offenses they could have included to list?
Bribery was the classic example for them of the high crime and misdemeanor of abuse of office for personal gain. Because if you take something of value, when you're able to affect an outcome for somebody else, you're serving your own interests and not the interests of the people. And that was commonly used in impeachment offenses in England, and that's one of the reasons that they specified it.
Thank you. Now, earlier in this hearing, Professor Carlin made the point that bribery as envisioned by the framers was much broader than the narrow federal criminal statute of bribery. I think the reason for that is obvious. We are not in a criminal proceeding. We're not deciding whether to send President Trump to prison. This is a civil action. It's an impeachment proceeding to decide whether or not we remove Donald Trump from his job. And so, Professor Carlin, it's true, isn't it, that we don't have to meet the standards of a federal bribery statute in order to meet the standards for an impeachable offense?
That's correct. I'm sorry, that's correct.
Thank you. Yesterday, Scalia law professor J.W. Verrett, who is a lifelong Republican, former Republican Hill staffer, and who advised the Trump pre-transition team, made the following public statement about Donald Trump's conduct. The call wasn't perfect. He committed impeachable offenses, including bribery. So, Professor Carlin, I'm now going to show you two video clips of the witness testimony relating to the president's withholding of the White House meeting in exchange for the public announcement of the investigation into his political rival.
As I testified previously, Mr. Giuliani's requests were a quid pro quo for arranging a White House visit for President Zelensky.
By mid-July, it was becoming clear to me that the meeting President Zelensky wanted was conditioned on the investigations of Burisma and alleged Ukrainian interference in the 2016 U.S. elections.
To the president's decision to withhold security assistance that Congress had appropriated to Ukraine in exchange for an announcement of public investigation of his political rival.
In the absence of any credible explanation for the suspension of aid, I later came to believe that the resumption of security aid would not occur until there was a public statement from Ukraine committing to the investigations of the 2016 elections and Burisma, as Mr. Giuliani had demanded.
Does that evidence, as well as the evidence in the record, tend to show that the president met the standards for bribery as envisioned in the Constitution?
Yes, it does.
I'm also a former prosecutor. I believe the record and that evidence would also meet the standards for criminal bribery. The Supreme Court's decision in McDonnell was primarily about what constitutes an official act. The key finding was an official act must involve a formal exercise of governmental power on something specific pending before a public official. Pretty clear we got that here. We have hundreds of millions of dollars of military aid that Congress specifically appropriated. The freezing and unfreezing of that aid is a formal exercise of governmental power. But we don't even have to talk about the crime of bribery. There's another crime here, which is the solicitation of assistance of a foreign government in a federal election campaign. That straight up violates the Federal Election Campaign Act at 52 U.S.C. 3101. And oh, by the way, that act is also one reason Michael Cohen is sitting in prison right now. I yield back.
The gentleman yields back. Mr. McClintock.